I never really thought too much about the importance of healthcare law until I got my subpoena for my first deposition. That got my attention. Hopefully, we can talk about some things related to healthcare law to protect you, to give you some confidence on how to practice, and also just give you awareness of the laws that impact nursing. That's what we're going to talk about today, healthcare law. Go ahead and get out your textbooks and study along with me. Today we're going to be in Giddens chapter 57 as well as Davis chapter 45. And here are the objectives that we hope to accomplish from this chapter. We're going to complete our concept study guide and then answer these questions. Where do we get our laws from? What's the purpose of healthcare laws for nursing? What are the governing bodies for nursing practice, both federal, state, and anything else? What are torts and how do they impact nursing practice? And finally, and sometimes it feels like most importantly, how do I minimize malpractice risk for myself? Nobody wants to lose their license over malpractice. We certainly want to do right by our patients. We want to practice both ethically and legally. I'm going to give you some tips on that today. So the definition of healthcare law is a collection of laws that either directly impacts the delivery of healthcare or impacts the relationships of those stakeholders, those key players in the healthcare world, different businesses, providers, recipients of the healthcare system. So it's laws that impact healthcare delivery and all of those of us who are involved in that delivery. And it's really a fundamental concept for all healthcare professionals, including nurses and nursing students, to understand. So the first question here is, where do we get our laws from? Where do these laws come from in the first place? So we have kind of three strands that all form the whole of sources of healthcare law. The first one being legislation. Legislation meaning laws passed by governing bodies such as Congress, both at the state or federal level, that helps guide laws that are passed that directly affect healthcare. The second one is judicial decisions, so case law. So judges who have judged specific cases, and then the findings of those cases become the rule of law through judicial decisions. And finally, and sometimes most importantly for what we do on a daily basis, is regulatory law. Different governing bodies, such as the Illinois Department of Public Health on the state level, or the Department of Health and Human Services on the federal level, that are given authority to govern and regulate healthcare as a whole. So if we were going to give some examples of these sources of law, an example of legislative law would be the Social Security Act and how we are able to get Medicare and Medicaid and Social Security to help support our patients through the acts of Congress that have passed those, both on the state and federal level. Judicial decisions, if you think about the Supreme Court case for Roe versus Wade that allowed legalized abortion in our country, that's a judicial decision that has become a source of law for healthcare. And finally, the regulation. Illinois Department of Public Health is the regulatory body that governs local and state level hospitals and healthcare facilities to ensure proper levels of care and certain rules and regulations that apply. And when I worked in the ER as the educator there, we would have visits from IDPH regularly to assess the safety of our hospital and of our department. So those are three examples of sources of law. So there are a number of types of laws that healthcare law encompasses. Statutory law are those legislative votes from Congress on the state or federal level. Administrative law are the regulatory bodies that govern healthcare. Tort law is considered malpractice. We're going to talk about that a little bit more. Common law means case law, things that judges have decided. Contract law are contracts between government agencies on how things are going to be oversaw. And then criminal law are illegal activities that are brought before the courts. And finally, constitutional law are things that are based directly on our Constitution, either the state or federal. So here are the attributes of healthcare law. Healthcare laws are created by some government body, whether legislative, some kind of regulatory agency, or by a court decision. And healthcare laws require or prohibit action and are usually enforceable by some kind of sanctions. Sanctions meaning consequence. These healthcare laws are publicly available and accessible. They have to be consistent with both the federal or the state constitution, and they can be modified. They can be changed, or they can be upheld by the courts. Let's take a look at the criteria for healthcare law. So let's face it, the people who make our laws, judges, legislators, they're not healthcare people. And so as they make these laws and they come up with these decisions, they really depend on professional organization, codes and standards of practice to influence what makes it right or wrong. So while it's not law, things that impact law or influence law are things like the American Nurses Association standards of practice, code of ethics, and even just what has been set up by different accrediting bodies like the Joint Commission. So while those are all not legally binding entities or codes, they really influence and direct how laws are made. So what's the point? What's the purpose of healthcare law for nursing? So listen, healthcare laws are meant to protect society. They give us a standard, they give us something to be held to, and a consequence if we don't. Nursing practice is guided then by legal principles, and the purpose of the law is to protect both patients and society as a whole, help give us a definition for the scope of nursing practice, which is done at the state level by the State Board of Nursing, and identifies a minimum standard of the level of care that needs to be provided. Make sure you understand what this slide says. This part's really key for what we do. So what governs nursing practice at the federal level? Well, there are a number of different federal laws that guide nursing practice and things that you may be familiar with. HIPAA, meaning protecting patient confidentiality. EMTALA, meaning not being able to turn people away in the ER if they're coming to seek care for having a medical emergency or being in labor. High tech for the way we manage and protect healthcare information in this age of technology. And then the Patient Self-Determination Act, which requires hospitals and healthcare providers to inform patients of their Bill of Rights as a patient. And then the Americans with Disabilities Act, the ADA, which protects those with disabilities to make sure that their healthcare is at the same level and accessibility as those with able bodies. And what governs nursing practice is the State Board of Nursing. Oh, can we just pause there? That's a good one to lean into a little bit. The State Board of Nursing. The State Board of Nursing. Did you hear it? The State Board of Nursing. It's got what governs our nurses' practice. And by that, I mean my license as a nurse is provided by the Illinois State Board of Nursing, and it's regulated through the Illinois Department of Public Health. So every couple years, I get a new license. Now it's electronic. I get a new license in my email from the Illinois Department of Public Health from the State Board of Nursing. And when I go to Wisconsin in the summer to volunteer as a summer camp nurse, which is super fun. Homesickness, by the way, is cured with popsicles and a game of Uno, just in case you were wondering. But when I go up to Wisconsin to do my summer camp volunteering, I have to have a Wisconsin license to practice, a nursing license, an RN license from Wisconsin in order to practice in Wisconsin. So I hold a license in both Illinois and Wisconsin because it's the State Board of Nursing that gives us our license as a nurse and also oversees that license to make sure that we are still allowed to have that. If I did something crazy and went off the rockers, the State Board of Nursing can remove my license. So the state boards of nursing, primary goal is public protection. We want to make sure those healthcare workers who are coming at with you with needles and scalpels know what they're doing and they're safe to practice. And the Board of Nursing uses a state legislation called the Nurse Practice Act in order to set the standards for practice. Oh, if you're not paying attention, make sure you are really tuning into this part, because the Board of Nursing and the Nursing Practice Act is everything for us as a nurse. It tells us what we can do, what we can't do, when we can do it, what are the requirements to get that to get your nursing license, and also manages any disciplinary procedures that are required. And so here, this slide lays out all of those things I just talked about, setting a standard of practice and a scope of practice, minimum education standards. It's the Board of Nursing that said an associate's degree in nursing is an appropriate degree to be able to sit for your boards and pass the NCLEX and get your nursing license in the state. Now, this is talked about on page 526 of Giddens, and I've also linked the Illinois Nurse Practice Act directly on Blackboard under course resources. And I would encourage you to pause here and go over there and read it. It's a little bit wordy, as most legislation is, but you gotta know what's guiding your practice as a nurse. In addition to the State Board of Nursing regulating nursing practice in that state, there are other state laws that guide nursing practice. So advanced directives, informed consent, and physician-assisted suicide are all legislated by the state law. And so that's why when we talked about the Brittany Maynard case in ethics and the right to die laws, she was able to have a physician-assisted suicide in Oregon because that state law said that that was okay, while other states have not passed legislation on that. So these specific types of practice are dictated by the individual state. So there's a couple other miscellaneous things that govern nursing practice. Let's take a look at those. So institutional policies and procedures. We have to present our policies and our procedure manuals to the state from a hospital, and then you as a nurse are held to the standard of practice for that hospital if there was ever a question about your practice and if you had, violated that. Now, the Nursing Code of Ethics, the Nurses' Bill of Rights, and the Nurses' Scope and Standards of Practice from the ANA are not law, but they're regularly accepted in court cases as a standard to guide legislators and judges who are not healthcare workers in influencing them and saying what is the accepted standard for our profession. So we've talked a little bit about standards of practice, but what does that mean? A standard of practice is a standard of care in which a reasonable and prudent nurse would do the same or a similar thing in the same scenario. In other words, is what you did what a good nurse would do, like a regular, normal, everyday, average nurse would do in that same situation? Because that's the standard. We're not looking for, the 1 out of 10 who's exceptional, but we're also not looking for falling below that line. So we as a profession kind of set the bar for ourselves on what is a acceptable form of practice. And these things come from state nurse practice acts, influence from accrediting bodies like the Joint Commission, as well as professional organizations like the American Nursing Association, or even specialty organizations like I'm a part of the Emergency Nurses Association, which sets standards of practice for ER nurses.